Chief Justice, distinguished guests, ladies and gentlemen, good evening. My name is Marilyn. I'm the Dean here at the Law School, and on behalf of my colleagues here at the Law School, it is a great pleasure to welcome you here to the Harold Ford Memorial Lecture. This year, as you know, the Chief Justice of Victoria, the Honourable Marilyn Warren, is going to speak to us, and my colleague, Professor Ian Ramsey, will introduce her in a moment. I begin by acknowledging that we meet on the traditional lands of the Wurundjeri people of the Kulin Nations, and I pay my respects to their elders past and present. Ladies and gentlemen, we're delighted that tonight's proceedings will be recorded. They'll be available after the lecture. Could I please ask even more so in those circumstances that you take a moment to either switch off your mobile phone or put them on silent for the duration of the lecture. The Harold Ford Memorial Lecture honours distinguished law school alumnus and Professor Harold Ford, who passed away in September 2012. This lecture is a celebration of the very many contributions of Professor Ford to this law school and to the wider legal profession. Professor Ford was appointed to Melbourne Law School in 1949 and spent almost his entire career here, including a period of time as Dean of the Law School in 1964 and from 1967 to 1974. Memories of those times are still very strong in the alumni group who are here, and they're spoken of with great fondness. He was, as many of you know, the sole author of the first 4 editions of Ford's Principles of Corporations Law, and was awarded a much-deserved honorary doctorate from the University of Melbourne in 1987. We have many special guests who are here with us this evening, and of course you are all very welcome. But could I particularly acknowledge our speaker for this evening, the Honourable Marilyn Warren, AC, Chief Justice of the Supreme Court, Mr Fred Hawke and Mr Andrew Walker, representing Clayton Utes, and I'd like to take a moment to acknowledge Clayton Utes, who also had a very close professional association with Professor Ford and who are tonight's generous sponsors of the event. I'll also acknowledge Professor Ford's son, John, and his partner Kate, who are with us tonight. We're delighted to have that representation from the family. I'd now like to invite my colleague, Professor Ian Ramsey, who himself holds the chair named after Professor Ford, to introduce the Chief Justice. And in so doing, I'd like to acknowledge Professor Ramsey's role in organising this evening and to thank Professor Ramsey, Hui and event staff for the work that they put into making tonight a success. Please welcome Professor Ramsey.
Thank you. I'm very pleased to introduce our speaker, Chief Justice Marilyn Warren. Chief Justice Warren was appointed Chief Justice of the Supreme Court of Victoria in November 2003. She is the 11th Chief Justice of Victoria. This evening's lecture is delivered in a year which is particularly auspicious for the Supreme Court. This year the Court celebrates its 175th anniversary. Chief Justice Warren holds the degrees of Bachelor of Jurisprudence, Bachelor of Laws and Master of Laws from Monash University. She commenced her legal career in the Victorian Public Service and was admitted to practice in 1975. She was employed in various government legal offices, including as a senior legal policy advisor to 3 Attorneys General. She was later appointed an Assistant Chief Parliamentary Counsel. Chief Justice Warren signed the roll of the Victorian Bar in 1985 and practiced in areas including administrative law and commercial law. She served as member of the Bar Council's Law Reform Committee for 8 years and in 1997 took silk. It was in 1998 that she was appointed to the Supreme Court of Victoria and presided in all jurisdictions, in particular the Corporations List and the Commercial List, of which she was judge in charge for 3.5 years. In 2004, Chief Justice Warren was awarded an honorary doctorate of laws by Monash University in recognition of her service to the law and to the community. In 2005, she was made a Companion in the Order of Australia for her services to the judiciary and the legal profession in the delivery and administration of law in Victoria, to social and economic conditions of women, and to forensic medicine. In 2006, Chief Justice Warren was appointed to the role of Lieutenant Governor of Victoria. Chief Justice Warren has held many positions in addition to her judicial appointments. They include her current positions as Chair of the Judicial Council of Victoria and Chair of the Council of Legal Education. Her previous appointments include President of the Victorian Law Foundation and Chair of the Victorian Institute of Forensic Medicine. The Chief Justice presides over an extraordinarily busy court. Almost 5,000 cases were initiated in the trial division of the court, according to the court's most recent annual report, together with almost 500 appeals. Her Honour has introduced many positive changes to the court during her time as Chief Justice. They include enhanced use of technology in court cases, which has been particularly evident in large class actions that have been heard in the Supreme Court, as well as important reforms to criminal appeals that have resulted in significant reductions in the time to decide appeals. For our purposes this evening, given the focus of the lecture on commercial law, it is particularly worth noting the success of the Commercial Court. The Commercial Court was established in 2009, initially with 4 lists to accommodate the growing demand for specialist judges to hear commercial law matters. It was in November 2013 that a dedicated Commercial Court registry commenced operations, and a number of innovations have since been introduced, including the enhanced use of mediation. In the most recent financial year, according to the court's website, the Commercial Court had 1,400 case initiations, with 90% of those being in the corporations list. These are just some of the many changes introduced at the Supreme Court while Her Honour has been Chief Justice in order to enhance the administration of justice. Given Chief Justice Warren's many significant and long-standing contributions to the law, it is with great pleasure that I invite her to deliver the 2016 Harold Ford Memorial Lecture on the topic Corporate Structures, the Veil, and the Role of the Courts.
Distinguished members of the Academy and distinguished guests and those interested in corporations law, thank you for coming this evening. I hope you will be interested and, who knows, even entertained. I particularly want to thank Professor Ramsey for his kind and warm welcome. Tonight I have chosen to speak about a topic that has been the subject of intense discussion for a long time, but which remains fascinating and in significant parts unresolved. That is the problem of the veil. That is, to what extent can courts look behind legal structures to commercial realities in determining the disputes before them? The topic of piercing the veil has been described as an unprincipled and arbitrary area of the law. In a sign of how controversial this area is, in the 2013 UK Supreme Court decision of VTB Capital, Lord Neuberger, the President of the Court, queried whether it was even possible for a court to pierce the corporate veil outside of a statutory mandate to do so. His Lordship subsequently drew back from this position in the case of Preston Petrodel, which was decided a few months after the former case of VIB. In press, Lord Neuberger was persuaded by Lord Sumption that the doctrine of veil piercing did have a place in the law, albeit a narrow one. In reaching that conclusion, however, Lord Neuberger remarked, and I quote, "It is clear from the cases and academic articles that the law relating to the doctrine is unsatisfactory and confused. Those cases and articles appear to me," Lord Neuberger, "to suggest that 1, there is not a single instance in this jurisdiction where the doctrine has been invoked properly and successfully. 2, there is doubt as to whether the doctrine should exist. And 3, it is impossible to discern any coherent approach, applicable principles, or define limitations to the doctrine." Now, the fact that the highest court in the UK was very recently having discussions about the existence of a purported legal principle that has been the subject of reams of legal writing is a clear sign, I would suggest, of the unsettled nature of this topic. Before I launch into any substantive discussion this evening, I first want to define the scope of what I will be speaking about. Some have drawn a distinction between strict veil piercing and the looser notion of veil lifting. Lord Justice Staunton in Atlas Maritime said the former involves treating the rights or liabilities or activities of a company as the rights or liabilities or activities of its shareholders, while the latter involves having regard to the shareholding in a company for some legal purpose. At the same time, some commentators and courts have used the terms veil piercing and veil lifting interchangeably. Tonight, I want to talk about the veil and scrutinising corporate structures in a broader sense rather than a narrower sense. The debate surrounding veil piercing or lifting in its broad sense is a rich area for case law and academic discussion, and I do not purport to provide any kind of comprehensive overview of the extant debates. Rather, I want to focus on a few areas which I think are interesting and usefully highlight the tensions the courts have to grapple with when faced with corporate structures. Now, first of all, control and shadow directors. A good place to start might be the collapse of Queensland Nickel, which has received considerable media attention in recent months. As has been widely reported, Queensland Nickel Proprietary Limited went into voluntary administration in January. Queensland Nickel operated the Yabaloo refinery, employing all the workers there and contracting with suppliers, but did not own any of the refinery assets. Between them, instead, those assets are owned by QNI Metals and QNI Resources. Now, between them, QNI Metals and QNI Resources hold all of the shares in Queensland Nickel. On 11 April this year, so just a month ago, FTI Consulting released its administrator's report on the company. The report estimated that Queensland Nickel owed over $200 million in secured and unsecured creditors. According to the news reports, these debts include workers' entitlements, unpaid council rates, and the cost of remediation of the refinery site. On 22 April, Queensland Nickel's creditors voted to put the company into liquidation in accordance with the administrator's recommendation. The first courtroom hearing involving Queensland Nickel has already occurred. In mid-April, QNI Metals and QNI Resources sought an interlocutory injunction in Queensland's Supreme Court to block FTI Consulting as administrators of Queensland Nickel from seeking to recover $190 million from them. Justice Burns was due to hand down judgment on the interlocutory injunction on Friday last week, but on the afternoon of 28 April, the applicants advised the court that they were withdrawing the interlocutory injunction application. According to an article in the Australian newspaper, Justice Burns was critical of this last-minute move, stating, and I quote, with some judicial sympathy I might add, His Honour said, "I've wasted enough time this week on this matter writing a judgment that won't be delivered." Judicial frustration. These situations reveal the promise and the problem of limited liability. Limited liability encourages desirable economic activity on separating out the reward from the risk. Contracts that advance shareholders' interests can be entered into while ensuring that recourse can only be made against company assets rather than their personal assets. This construction is an accepted reality of business. The risk of insolvency is instead borne by creditors, whom, it is argued, are able to factor that risk into their required return. An existing incursion into the corporate veil is that limited liability applies to shareholders but not to directors. Courts can and do look through the company to its actors and penalise those who, for example, fail the duty enshrined in Section 181 of the Corporations Act to act in good faith in the best interests of the company. As Sir Anthony Mason noted in Walker and Wimborne, it should be emphasised that the directors of a company in discharging their duty to the company must take account of the interest of its shareholders and its directors. Any failure by the directors to take into account the interests of creditors will have adverse consequences for the company as well as for them. To return to Queensland Nickel as an example, the April administrator's report into the company expressed the opinion that there had been, quote, reckless, quote, conduct by the directors. The administrators stated that since mid-2012, over $189.3 million of related party loan balances has been forgiven by Queensland Nickel for the benefit of director-related parties. The report also noted an additional $26 million was transferred as donations to political parties, transfers which may have indirectly benefited a director of Queensland Nickel. The administrators also expressed the view that Mr Clive Palmer, a former director of Queensland Nickel, quote, appears to have acted as a shadow de facto director of Queensland Nickel at all material times from February 2012. Quote, excluding 3 periods in which he was an appointed director, most recently ending in February 2015. Mr Palmer has denied this allegation. Recognition of shadow directors is a powerful way in which the courts look past corporate structures to the commercial realities behind them. However, it is not lightly exercised. The extension of directors' responsibilities to those who assist in decision-making carries the risk of inculpating myriad professional advisors. For example, it is not uncommon for lenders to get involved in attempts to save troubled companies. In this context, the analysis of exactly what Buzzell Operations and Apple Computer Australia, which was approved on appeal by the New South Wales Court of Appeal, the directors collectively in the exercise of their powers of management, the court said, must be accustomed to act on the instructions or wishes of the putative shadow director for the definition to be satisfied. In his exploration of this definition, Justice White noted that although this did not require proof that the directors of the company exercised no discretion of their own, it did require a causal connection between the instruction or wish of the shadow director and the act taken by the directors. This requirement is logically sound, but practically may be difficult to apply. For example, in Buzzell, Apple had insisted on Buzzell being restricted from incurring financial indebtedness outside a certain prescribed list of permissions. A Buzzell director deposed that he felt he had no choice but to agree to this term. Certainly the arrangement indicated Apple's influence on Buzzell's management. However, the expectation or presumption is that individual directors are to responsibly exercise their independent judgment. There are numerous commercial arrangements where a company or an individual is in a dominant position. As Justice White reasoned in the judgment, for a company to insist on such terms in a commercial dealing between a third party and the company is not ipso facto to give an instruction or express wish as to how the directors are to exercise their powers. Unless something more intrudes, the directors are free and would be expected to exercise their own judgment. Another recent example where the issue of shadow directorships arose is the Royal Commission into Trade Union Governance and Corruption conducted by former Justice Dyson Heydon. There was a suggestion that an individual directed the operation of 2 businesses which had each reportedly been through around 4 companies that had been liquidated with outstanding assets. The individual was not a director. At the hearing, the questions of counsel assisting the Royal Commission resolved around the individual's practical control of the businesses, yet the testimony provided fell short of satisfying the threshold test set out in Buzzell. When asked if the individual gave directions, an appointed director responded, quote, not specific directions, but certainly most things were discussed with him, end quote. Shadow directorships can demonstrate attention. It is important to ensure that those defrauding creditors are held accountable, but the scrutiny of interpersonal dynamics and commercial realities is complicated by the important presumption that directors are free-thinking actors. Now I turn to limited liability and corporate groups. Groups are such a ubiquitous commercial structure. The advantages of corporate groups as economic units to carry on business have been thoroughly canvassed elsewhere. Needless to say, there are very good reasons why corporate groups have become the structure of choice for commercial enterprises. A 1997 empirical study of the top 500 ASX listed companies by Professor Ian Ramsey and Jeff Stapleton found that 89% of those companies controlled at least one other entity, and that 90% of the controlled entities were wholly owned. A 2007 update on Professor Ramsey and Jeff Stapleton's study by two University of Sydney academics produced very similar statistics. The prima facie position reached by applying the principle from Salomon and Salomon to corporate groups is that each member company of a corporate group is a separate legal entity. So creditors are generally expected to only look to the group member with which they have contracted, and the group can structure itself so that liability from its activities will fall on a particular member and that member only. As Lord Templeman commented rather colourfully in re Southard, company law possesses some curious features which may generate curious results. A parent company may spawn a number of subsidiary companies, all controlled directly or indirectly by the shareholders of the parent company. If one of the subsidiary companies, to change the metaphor, turns out to be the runt of the litter and declines into insolvency to the dismay of its creditors, the parent company and the other subsidiary companies may prosper to the joy of the shareholders without any liability for the debts of the insolvent subsidiary. Now, corporate groups effectively take the protection offered by limited liability and double it. The shareholders of a parent company that allocates a risk-bearing activity to its subsidiary receives a dual layer of protection. The first layer being the limited liability enjoyed by the parent in respect of the liabilities of the subsidiary, and the second being the limited liability enjoyed by the shareholders in respect of the liabilities of the parent. As many commentators have pointed out, the limited liability principle preceded the rise of the corporate group. Salomon itself was centred around a one-man or private company. Corporate groups were virtually unknown at the time of that decision. Yet when they begin to emerge, the principle from Salomon was applied to this new structure without detailed consideration of the rationales underlying the decision in Salomon and whether those rationales apply equally in the corporate group context. Academics have identified a number of bases on which parent company shareholders are distinguishable from individual shareholders when it comes to the issue of limited liability. In a 2001 article, Professor Ramsey and David Noakes observed that typical justifications for limited liability, such as reducing the need for shareholders to monitor management, promoting the free transfer of shares, and permitting efficient diversification by holders, have limited or no application to parent companies. Professor Helen Anderson of this law school has also observed that imputing a subsidiary's liability to a parent company does not impose unlimited personal liability on any individual shareholder. There is a lot of merit in these arguments. The problem, however, is that the Salomon principle is now so entrenched in our law, it has become almost too late for the courts, at least, to return to a first principles analysis of the desirability or otherwise of the application of limited liability to corporate groups. To borrow the language of Lord Templeman, the Salomon principle has become an unyielding rock on which complicated arguments become shipwrecked. High Court decisions such as Walker and Wimborne and Industrial Equity and Blackburn direct a strict application of the separate entity doctrine by Australian courts, and thus a corresponding judicial reluctance to engage in veil piercing. Justice Dodd-Streeton described this reluctance in the case of Varangian and OFM Capital. Her Honour said, underlying unity of economic purpose, common personnel, common membership and control have not been held to justify lifting the corporate veil. Even the complete domination or control exercised by a parent over the subsidiary is not a sufficient basis for lifting the corporate veil. Her Honour continued, this is an area in which the law pays scant regard to the commercial reality. This attitude towards the veil has manifested itself in a variety of contexts. One recent example is the BHP Billiton litigation concerning tax deduction claims. In that case, BHP Billiton had established a wholly owned subsidiary treasury company, which I will call Finance. Finance's role was to borrow large sums of money from third parties at commercial rates of interest and loan those funds to entities within the BHP Billiton Group to fund operational activities and new projects. Loans made by Finance to related entities were charged at a higher rate of interest, which earned substantial profits and generated income tax liabilities. Finance's workforce was drawn from other companies within the group. Its directors were appointed by the parent company, and its decision-making had regard to group interests. In disputing tax deductions claimed by Finance, the Commissioner of Taxation sought to argue that Finance was a mere conduit of its parent. This argument failed to find favour with the trial judge and on appeal to the full Federal Court, and the High Court refused leave to appeal on this point. Associate Professors Hargovan and Jason Harris commented shortly after the decision of the full Federal Court that the outcome of the BHP Billiton litigation was unsurprising in light of Australian courts' steadfast application of the Salomon principle in the context of corporate groups. Indeed, despite the arguments for piercing the corporate veil more frequently in the case of parent-subsidiary relationships, Professor Ramsey and David Noakes' influential empirical study of all Australian veil-piercing cases up to December 1999 showed that, surprisingly, the veil is less likely to be pierced in parent-subsidiary cases compared to cases involving one or more individual shareholders. Now, as has been demonstrated by history, the strict application of the separate entity doctrine by the courts may lead to results that are discomforting to the public. In 1993, in the introduction to an edited collection entitled The Law Relating to Corporate Groups, Michael Gulhuli wrote, "The law's reluctance to broaden its focus beyond the individual companies that comprise corporate groups to take in the group as a whole has led to a growing tension between legal theory and commercial expectations and practice." Now, if I may say, I think an editor of a modern book on corporate groups could validly continue to express that sentiment. In the same book, edited by Emeritus Professor Gulhuli, then Justice Andrew Rogers argued that Australian law had failed to come to grips with the commercial reality of a world dominated by conglomerates with subsidiaries in different fields of activity and locations, as opposed to single companies. His Honour was echoing similar observations he had made in Quintex Australia and Schroders, where he called for consideration of legislative reform in an area where fairness or equity seems to have played little role. One of the most notorious examples of the perceived unfairness of corporate group structures is the James Hardie saga and the James Hardie Group's treatment of liabilities to people who had been harmed by its asbestos products. The report of the New South Wales Royal Commission of Inquiry into James Hardie's Asbestos Compensation Fund was critical of the arrangements that had led to the separation of the compensation fund from the other parts of the corporate group, the latter of which were relocated overseas. The James Hardie case has been analysed in depth by a number of academic articles, and I do not wish to cover the same ground tonight, but I will make the following observation. Part of the fuel behind the public outrage at the James Hardie Group's behaviour was, I would suggest, for courts, of course, issues of corporate morality and fairness are constrained by established legal principles. This was noted by my former colleague Justice Byrne in Premier Building and Spotless, in which a parent company sought to distance itself from the consequences of chemical contamination caused by its subsidiaries. Justice Byrne expressed the view that the parent company's stance reflected poorly on the commercial morality of the managers of the parent company, but His Honour continued, "That said, I emphasise that this is not a court of morals." This case, like any other, he said, will be decided according to law. If sweeping changes are to be made to veil piercing within corporate groups, that will have to be done by legislation. Some statutory change has already occurred to a limited extent with the introduction of Section 588V of the Corporations Act, which imposes liability on holding companies for the insolvent trading of their subsidiaries in certain circumstances. Given the current lack of clarity around the circumstances in which veil piercing will occur, statutory codification of veil piercing could well be an opportunity to provide some certainty in this area. I note, however, that previous suggestions for large-scale legislative reform in the area in the shape of the Harmer Report and the Companies and Securities Advisory Committee's suggestion of an opt-in procedure to create consolidated corporate groups have fallen by the wayside. I will not hazard a guess as to how long it will be, therefore, before sufficient impetus to bring in legislative change in this area occurs to lift it out of the too hard basket. Now, I wish to turn to what might seem a rather unexpected area of law in this context, particularly as there's probably a dominance this evening of corporations and trust lawyers present. I want to turn to tort law, or at least tort law as it intersects with corporations law. In particular, I want to speak about cases that have imposed liability in negligence on a parent company for a breach of duty of care to an employee of its subsidiary, and to consider the ramifications of those cases. This issue gained some prominence in the UK in recent years with the decision of the English Court of Appeal in Chandler and Cape. That case represented the first time in the UK that a parent company was found to have been directly liable for breach of duty of care to an employee of its subsidiary. The same issue has been considered at some length by Australian courts in a series of cases in the late 90s. Unfortunately, the Court of Appeal judgment in Chandler does not appear to have been referred to in those cases. Now, the facts of Chandler were as follows. Mr. Chandler had been employed in the late 60s and early 60s as a brickloader by a company called Cape Products. There was an asbestos factory on the site where Mr. Chandler worked, which had open sides. No measures were taken to prevent the asbestos from the factory escaping into the brickyard. Mr. Chandler was therefore exposed to asbestos, and many years later he contracted asbestosis. By this time, Cape Products, the company, had ceased to exist. However, its parent company, Cape, still existed. Mr. Chandler sought to recover damages from the parent company. He alleged that the parent company owed a direct duty of care to employees of Cape Products to ensure a safe system of work. During Mr. Chandler's employment with Cape Products, all of its shares were owned by the parent company. The asbestos factory had originally been owned by the parent company, but it sold the asbestos business to Cape Products before Mr. Chandler commenced his employment. The board of Cape Products always had one or more directors of the parent company on it, and its meetings usually took place at the parent company's head office. Minutes from Cape Products board meetings indicated that the board's decision-making was at times expressed to be subject to approval by the board of the parent company. Cape Products was unable to incur capital expenditure without the parent's approval. Products made at the Cape Products asbestos factory were manufactured in accordance with the instructions and product specifications issued by the parent company, and product development was carried out in the parent company's central laboratory. Now, having said that, Cape Products remained a separate company to its parent. It owned its own assets and handled its sales with third parties. On health and safety issues, Cape Products was responsible for the day-to-day implementation of health and safety measures at its factory. It had its own works doctor and a works safety committee. But the parent company also looked at the health and safety issues for the whole group of companies. It appointed group medical advisors from the 1950s onwards, and there was evidence that those advisors conducted extensive research into the link between asbestos and lung disease. Now, against this background of facts, the English Court of Appeal found that the parent company owed a direct duty of care to Mr. Chandler. The focus of the judgment of Lady Justice Arden, with whom Lord Justices Moses and Macfarlane agreed, was on the proximity step in the three-stage Caparo test used by the English courts in determining novel duty of care issues. Lady Justice Arden held that it was not necessary for a parent company to exercise absolute control of the subsidiary for a direct duty of care to arise. Here, there was sufficient or relevant control exercised by the parent company over Cape products, demonstrated by the parent company's practice of issuing instructions to its subsidiary and the subsidiary's consideration of parent company and group interests in its decision-making. Lady Justice Arden identified 4 factors in addition to the control exercised by the parent company over Cape products that made this an appropriate case to impose a direct duty of care. These factors were that 1, the businesses of the parent and subsidiary were the same. 2, the parents had superior knowledge on health and safety issues in the industry. 3, the parent knew the subsidiary's system of work was unsafe. And 4, the parent knew or ought to have foreseen that the subsidiary or its employees would rely on the parent using its superior knowledge for the employee's protection. Interestingly, Her Ladyship commented that in looking at the last requirement, the focus was not on the parent's intervention in health and safety issues. She said, the court will look at the relationship between the companies more widely. The court may find that the 4th element is established where the evidence shows that the parent has a practice of intervening in the trading operations of the subsidiary, for example, production and funding issues. So, the English Court of Appeal took a fairly broad approach to looking at the relationship between a parent company and its subsidiary in determining whether the parent should be held to owe a direct duty of care. The subsequent English Court of Appeal case of Thompson and Renwick, also an asbestos case, drew some boundaries around the Chandler decision. There, the parent company in question did not carry on any business apart from holding shares in other companies. The parent had appointed an individual as a director of its subsidiary with responsibility for health and safety matters. The plaintiff, who worked for the subsidiary, had argued that this was this was sufficient to give rise to a duty of care to him on the part of the parent. The Court of Appeal rejected this. It held that in the day-to-day operations of the subsidiary, the director in question was not acting on behalf of the parent, but pursuant to his fiduciary duty to the subsidiary. The Court of Appeal further held that the totality of the circumstances of the case did not give rise to a duty of care on the part of the parent. The court noted that the parent did not conduct its own business. There was no evidence that the parent had special expertise in asbestos safety issues, and the finding of the trial judge that the parent and the subsidiary shared resources and intermingled their businesses were insufficient to demonstrate that the separate legal personalities of the parent and subsidiary were not respected. Nonetheless, the court in Thompson did not resile from the tests laid out by Lady Justice Arden in Chandler, and indeed remarked that the factors set out by Her Ladyship do not exhaust the circumstances in which a parent company may owe a direct duty of care to those who interact with its subsidiary. So it might be said, watch the English space in that regard. In cases, the approach taken in Chandler can be contrasted with that taken by the Australian courts in a series of cases in the 1980s and 90s. The first case that directly imposed liability on a parent company for serious injury to an employee appears to have been the 1988 decision of Justice Rowland of the Supreme Court of Western Australia in Barrow and CSR. In that matter, two former employees of Australia Blue Asbestos, which I will call ABA, a company involved in the mining and milling of asbestos at the Wittenoom asbestos mine, sued both ABA and its parent company for the mesothelioma and asbestosis that its employees suffered later in their life. The plaintiffs were able to successfully establish before Justice Rowland that, as then required under the test for duty of care in negligence cases, there was the requisite proximity between themselves and the parent company, such that the parent company owed them a duty of care to take reasonable care for the safety of the plaintiffs. Justice Rowland's preferred lens for looking at the relationship between parent and subsidiary was one of agency. There had been an agreement which was in terms sufficient whenever it was invoked to create an agency at law to enable CSR to direct all that occurred at the asbestos mine. His Honour said that whether one defines all of the above in terms of agency, and His Honour said in his view it is, or control, or whether one says that there was a proximity between CSR and the employees of ABA, or whether one talks in terms of lifting the corporate veil, the effect is the same. The next case I will mention was CSR and Wren, which was decided in 1997. In short compass, the plaintiff in CSR had inhaled asbestos fibres whilst employed by Asbestos Products Proprietary Limited, an asbestos cement manufacturing business during the early 1950s. The factory in which the plaintiff worked was poorly ventilated and had no windows. The employees were not provided with protective masks. The plaintiff developed mesothelioma in the 1990s. By that time, Asbestos Products had long since been liquidated. Asbestos Products was a wholly owned subsidiary of CSR and was described as being part of CSR's Building Materials division. All of the directors on the board of Asbestos Products directors was also CSR's Chief Executive Officer of the Building Materials division. Management staff at the factory were all employees of CSR. The management staff routinely entered the work areas where the manufacturing process was carried out. CSR controlled the purchase of equipment by Asbestos Products. The plaintiff did not seek to press the agency argument that had found favour with Justice Rowland on the facts of Barrow. Rather, Justices Beasley and Stein, with whom Justice Powell agreed, decided that a duty of care was owed on the basis that, given the fact that the whole of the management staff who had responsibility for the operational aspects of Asbestos Products enterprise, and therefore the conditions in which Mr. Wren worked, were CSR staff, CSR had a duty directly to Mr. Wren, and that duty was coextensive with that owed by an employer to an employee. The New South Wales Court of Appeal emphasised the narrow scope of the decision. They noted that in that case, the parent company had a close involvement in the subsidiary's activities over and above that expected in the case of a holding company. The judgment in Wren was quickly followed in another case by CSR and Young, a decision again of the New South Wales Court of Appeal in early 1998. Young involved the asbestos mines at Wittenoom, which were also the subject of the Barrow case. Now, it is an interesting case because the plaintiff there was not an employee of the subsidiary that putatively ran the asbestos mines, but rather was a resident in the town situated next to the mines. Asbestos tailings were used throughout the town, including to form roads, to construct the airport, and as ground fill in the town hospital, school and backyards. The plaintiff, who had lived in the town as a young child, later contracted mesothelioma. She sued both ABA and its parent company. CSR conceded, in light of the decision in Barrow, that it, as well as ABA, owed a duty of care to the workers at the asbestos mines and in the mills. However, it resisted liability for injuries to the town residents. The New South Wales Court of Appeal rejected that distinction. Justice Giles, with whom Justices Handley and Cohen agreed, noted that CSR had established ABA as its wholly owned subsidiary and caused ABA to give it comprehensive powers as agent. It did not matter whether the putative victim was an employee or not. The reality, the court said, is still that CSR was engaged in the relevant acts and omissions through ABA. A few months after Young, the New South Wales Court of Appeal handed down James Hardy and Hall, which underscored the narrowness of the court's previous decisions. The leading judgment in James Hardy was written by Justice Scheller, with whom Justices Beazley and Stein agreed. Now, you may recall that Justices Beazley and Stein had sat on the Wren case. James Hardy involved a New Zealand plaintiff who had been exposed to asbestos dust at his place of work. He sought to recover from his New Zealand employer as well as the two New South Wales companies related to his employer. One of those New South Wales companies, referred to as the holding company in the judgment, held over 95% of the shares in the New Zealand company. The other New South Wales company was a subsidiary of the holding company. The plaintiff alleged that both New South Wales companies had the control and management of the New Zealand factory where he had worked. The trial judge had imposed liability on the New South Wales companies on the basis that the total of the evidence suggested that the three companies conducted one enterprise. The trial judge referred to the fact that the New South Wales subsidiary would regularly give instructions to the New Zealand company which were adopted. The New Zealand company would also hold its directors' meetings and annual general meetings in Sydney. Correspondence between the New Zealand and New South Wales companies was on an inter-house basis. The asbestos acquired by the New Zealand company was procured by the New South Wales companies and then allocated to the New Zealand company. The New South Wales subsidiary provided both technical information on the manufacture of asbestos products and safety information about the risks of inhalation of asbestos dust to the New Zealand company. The New South Wales subsidiary also recommended approval of capital expenditure by the New Zealand company. So you can see the interactivity. The Court of Appeal rejected the trial judge's analysis and found that there was no duty of care on the part of the New South Wales company. The court found that the incidences of control referred to by the trial judge were insufficient to justify lifting the corporate veil. Justice Scheller referred to the comments of Lord Keith in Wolfson and Strathclyde Regional Council that it is only appropriate to pierce the corporate veil where special circumstances exist, that it is a mere facade concealing the true facts. On the evidence here, the Court of Appeal said it was not open to the trial judge to find that the New Zealand company was a mere facade concealing the fact that the plaintiff was in fact employed by the New South Wales companies, or that the New Zealand company was merely acting as the other company's agent. The plaintiff had relied upon Wren in its submissions. The Court of Appeal distinguished Wren and interpreted it narrowly. The court said in CSR and Wren it was the employees of CSR who controlled the day-to-day operations of the subsidiary. The factory manager and foreman was a CSR employee. CSR had direct control of the operational aspects of its subsidiary's factory. These facts illustrate, the court said, that CSR and Wren is a very different case from the present one. CSR and Wren did not involve any question of lifting of the corporate veil. Before I turn to consider the differences between the Australian and English approaches to this issue, I want to briefly mention the situation in Canada. There is yet to be a final case along the lines of Chandler or Wren decided in Canada, but there are a few cases in the pipeline which involve plaintiffs attempting to sue Canadian parent companies for the conduct of foreign subsidiaries. A high-profile example is Choc and Hudbay Minerals. In that case, a group of Indigenous Guatemalan plaintiffs have brought proceedings against Canadian mining company Hudbay Minerals, alleging that security personnel hired by Hudbay's 98.2% owned subsidiary in Guatemala committed a number of human rights abuses in the course of their employment. The plaintiffs allege that Hudbay owed a direct duty of care to them to prevent the harm in question. Hudbay attempted to have the proceedings struck out as disclosing no reasonable cause of action. In 2013, the Ontario Superior Court of Justice ruled that the matter could proceed to trial. Justice Bowen held that on the facts as pleaded, it was not plain or obvious that no duty of care could be recognised. Since then, the case has slowly wound its way through the initial phases of litigation. The last courtroom battle was in June of last year, 2015, over discovery. It will be interesting to see how the case is resolved if and when it finally makes its way to trial. It has the potential to provide another fascinating plank in the jurisprudence on direct liability of parent companies in tort. And if a duty of care is found, it is likely to have a profound impact in Canada, which is home to over 50% of the world's publicly listed exploration and mining companies, and for all international parent companies with foreign subsidiaries. I turn now to compare the approaches to the tort liability of parent companies in the UK and Australia. If we compare Chandler and the Australian cases, it is evident that the English law has taken a more generous approach when delimiting the circumstances in which it will consider imposing a duty of care on a parent company. The parent-subsidiary relationship, as described in Chandler, is among the Australian cases most similar to James Hardie. In both cases, it could not be said that the parent actually controlled the day-to-day running of the asbestos operation, or that there was an agency relationship between the parent and the subsidiary. Rather, there were features of parent company control of the subsidiary, such as the issuing of instructions to the subsidiary, parental approval for capital expenditure, products manufactured to parent company standards, and superior knowledge on the part of the parent company regarding health issues. In Chandler, these features were enough to sustain a duty of care on the part of the parent, but in the judgment of the New South Wales Court of Appeal in James Hardie, they fell short of the circumstances required to lift the corporate veil. The narrowness of the Australian approach, compared to that taken by the English Court of Appeal in Chandler, is exemplified by the obiter comments of Justice Rogers in Briggs and James Hardie. His Honour took the view that the fact a parent exercised complete dominion and control over another did not necessarily mean that the corporate veil should be pierced. His Honour said the law pays scant regard to the commercial reality that every holding company has the potential and, more often than not, in fact does, exercise complete control over a subsidiary. In contrast, Lady Justice Arden approached the issue from the other direction, saying in Chandler that it was not necessary to show absolute control of the subsidiary by the parent for a duty of care to be imposed on the parent. Of course, the Australian cases leading up to and including James Hardie were decided on the basis of the proximity test for duty of care, which was subsequently rejected by the High Court. But the analysis in those cases was not wedded to the proximity analysis, such that they would not be relevant under the modern salient features approach. In any case, the key difference between the English and Australian approaches is not so much the different tests applicable for duty of care, but rather a difference in attitude towards imposing direct liability on parent companies. The approach in the Australian cases is rooted in a reluctance in corporations law to lift the corporate veil, and thus sets the bar high for the parent-subsidiary relationship that will give rise to a duty of care on the part of the parent. The approach taken by the English Court of Appeal in Chandler, on the other hand, applies tort law without as much regard to the consequence that the imposition of a duty of care on the parent could have the practical effect of circumventing the separate legal status of group companies. Now, both the trial judge and the Court of Appeal in Chandler were keen to emphasise that their decisions in finding that the parent company owed a direct duty of care to Mr. Chandler did not raise issues of piercing the corporate veil. That is true as a matter of doctrine. The English courts did not impose a duty of care on the parent company because of the parent-subsidiary relationship, or because it considered the separate legal status of the subsidiary was a sham. Be that as it may, decisions such as Chandler and Wren do as a practical matter have the effect of scaling back the benefit of limited liability for group entities. As you can imagine, of skirting the corporate veil in cases such as Chandler, Wren and James Hardy. One of the challenges of these cases is that they lie at the hazy intersection of company and tort law, where bedrock principles such as limited liability, separate corporate personality and traditional principles of negligence collide. Tort law's objectives, including providing compensation for loss and injury and deterring wrongdoing, sit uneasily with the principle of limited liability where a company is unable to meet a judgment debt or it has been liquidated. One feature to note is that these cases involve what can be called involuntary creditors. Tort creditors generally have no or little choice as the company that inflicts injury on them. In this sense, they regard that they stand apart from the usual contract creditors of a company for whom the law is reluctant to lift the corporate veil. It also has to be remembered that tort creditors are usually victims of serious personal injury and are therefore particularly vulnerable. Further, it has been noted that the company will usually be the cheapest cost avoider, since it has the ability to take out insurance or other precautions in relation to the activities in which it engages. All of this provides a basis for approaching tort liability within corporate groups differently to other actions involving corporations. Issues of deterrence also arise. Excessive risk-taking by subsidiaries, egged on by parent companies that enjoy limited liability, could lead to a significant social cost if the subsidiary causes a number of tort victims along the way. That cost may ultimately outweigh the economic benefits that are often cited in support of limited liability. At the same time, caution must be exercised so that the principles of tort law are not distorted in order to achieve what are seen to be desirable results. Some academics have suggested abrogating limited liability altogether for corporate torts. Such a result could not be achieved in a doctrinally coherent way by the courts. It would require legislative intervention to effect such a large-scale change to the principles of both tort law and corporations law. In the aftermath of the Chandler case, some academics criticised the decision as lowering the bar too much. In an article in the Modern Law Review, Martin Petrin noted that it is in the very nature of vertically organised group companies that the parent will exert a substantial amount of control over its subsidiaries. Petrin argued that Chandler could open the floodgates for all sorts of tort proceedings against parent companies by individuals affected by the actions of their subsidiaries. It will be interesting to monitor the aftermath of Chandler in the UK, but so far it does not seem to have resulted in much litigation that has reached the courts. It was a pillar of the plaintiff's arguments in the Thompson case, which I have mentioned, but no duty of care was found on the part of the parent company in that case. I think it needs to be remembered that this kind of litigation against a parent requires the plaintiff to provide a considerable amount of evidence about the parent-subsidiary relationship and the control the parent exerts over the subsidiary. This is no easy task, the burden of proof in many cases, particularly where the events in question, as in asbestos cases, occurred decades ago. This factor, I think, reduces the likelihood of regular tort proceedings against parent companies for the activities of their subsidiaries. Rather, it seems to me that they would be a proceeding of last resort for plaintiffs. The Australian experience has certainly been that direct parent liability has almost completely fallen off the radar, although much of that can probably be attributed to the narrow approach taken in the Australian cases. Having said that, while most of the Australian and English cases have arisen around the parent-subsidiary-employee relationship, the case of CSR and Young demonstrates that the parent company can owe a duty of care to a person other than an employee who is affected by their subsidiary's activities. This presents a potential avenue for the further expansion of direct parent liability, subject of course to the legal and evidentiary requirements to show a sufficient parent-subsidiary relationship to justify the imposition of a duty of care. And going even further down this path, there is the possibility of holding parent companies directly liable for the activities of their foreign subsidiaries as they impact on non-employee plaintiffs. The Canadian proceeding in Chock and Hud Bay Minerals is an example of an attempt to do this. These kinds of proceedings often raise private international law issues, which I will not go into here. But to the extent that jurisdictional impediments can be overcome, they could become a prominent area of this kind of litigation, given the prevalence of transnational corporate groups in the modern globalised world. My conclusion. As I hope I have demonstrated, the topic of the corporate veil is a complex but fascinating one. The tension between legal doctrine, commercial realities, and public perceptions of fairness in the context of corporate groups is unlikely to dissolve anytime soon. The court's hands in this area are to a large extent tied. In light of this, rigorous academic research and law reform proposals have an essential role to play in the development of the law on the corporate veil. That is a fitting point to reach tonight, as we reflect on the achievements of Professor Ford, who through his academic writing and extensive law reform work has left an indelible mark on modern corporations law. Thank you.
The veil and the role of the courts. Undoubtedly, those who practice or research in this area have benefited considerably from your ideas. In addition, I believe we've been challenged this evening, and appropriately so, by the arguments you have made. Please join with me in thanking the Chief Justice for her excellent presentation. And that concludes this evening's lecture. Thank you very much for your attendance, everyone.